earlier this week rocked the Hallyu world. Her apparent suicide prompting the outpouring of grief and questions over cyberbullying. Her unconventional stand on issues like abortion, mental health, and even wearing bras made her the subject of harsh online criticism. News like this brings the conversation back to cyberbullying. And while global awareness of cyberbullying is increasing, 1 in every 4 adults still have zero or little information on how to combat it. Is it time for the law to step in? Hello, I'm Lexi Schultz. Welcome to Square Off Season 18, the VNA Law Debates. A 22-year-old UP fratman killed in September, a victim of alleged hazing and cyberbullying. The head coach and open spiker of the Philippine national women's volleyball team also falling prey to a barrage of criticism and hurtful comments online. People can be mean, and technology is only giving man more avenues to bully or be bullied, oftentimes anonymously. These days, it's no longer enough to just duck out of the back door. Technology and social media have made bullying easier and more ubiquitous. According to UNICEF data, 1 out of every 3 young people surveyed in 30 countries say they've been a victim of online bullying. 1 in 5 young people say that they've skipped school due to cyberbullying and violence. In the Philippines, data shows that cyber violence or electronic aggression affects almost half of children aged 13 to 17. 1/3 of cyber violence experienced by Filipino children are in the form of verbal abuse over the internet or through cell phones, while 1/4 are through sexual messages. As the headlines constantly remind us, bullying is not a joke. It causes permanent damage to individuals. Sometimes it even kills. While the Philippines has the Anti-Bullying Act of 2013, should cyberbullying be criminalized? Arguing for the affirmative side is Tarlac State University. From the university that provides quality education in the Central Luzon region, the future lawyers of Tarlac State University.
I'm still taking board exam, then I decided to enter law school impulsively due to certain circumstances where it tests me to persevere in law school.
I took up law because I have always searched for my other purpose other than teaching, because teaching has been my first love. And then later on, I realized that when you are engaged into student leadership, you would also find a lot of different kinds of injustices that your attention would then be leading towards the pursuit of justice as well.
This is my ultimate dream, and I believe that when I become a lawyer, I would also become an instrument where I could provide to the less in life to have them more in law.
Team Tarlac State University. Competitive, empowered, excellent. Taking on the negative side is University of Batangas. From the university in pursuit of knowledge, values, and skills, the next generation lawyers of University of Batangas.
I think that's actually in elementary days when I realized that I really want to be a lawyer. I think it's when I saw Madam Miriam Defensor Santiago on TV. I took up law because basically it's a dream and I cannot envision myself doing anything else or studying anything else.
It may sound very cliche or too idealistic, but I want to take up law to defend people who cannot defend themselves and to help them learn more about the law.
It's my first time to debate ever, and it's in national television. It's challenging, but my seniors in law school helped me on how I can improve and on how I can win my arguments without sufficient evidence.
Team University of Batangas. Spirited, intellectual, tenacious. Let's now meet our distinguished judges. First off, we have attorney Diane Marie Roa Oarde. She's a senior associate at VNA Law. Then we have attorney Alvin Clyde Gregorio. He is a founding partner at the Patak Plaza, Gregorio, and Tesalona law offices. One fun fact about him, he's actually our champion debater for seasons 5 and 7. And presiding as our chief adjudicator, we have Judge Tarcelo Sabare Jr., presiding judge at the Regional Trial Court, Branch 30 in Basay, Samar. The word war begins when Square Off Season 18, the V&A Law Debates, returns. Please stay tuned. Using a modified Oregon Oxford format, the debate is between two sides, the affirmative and the negative, with 3 members each. Each debater from the affirmative side argues the necessity, beneficiality, and practicability of the proposition, while the counterpart debaters on the negative side oppose these arguments. Each debater is given 4 minutes to deliver a constructive speech and rebut the previous argument. Each debater is given 2 minutes to interpolate or cross-examine the opposing debater. Only categorical questions may be asked. Each of the judges may ask 1 question of each speaker within that speaker's time limit. The judges score each team in terms of manner, matter, and interpolation. The team with a higher score from each judge gets a point. The team with the most number of points wins the debate. The chief adjudicator rules in the event of ties, objections, or contestations. This week's proposition, let it be resolved that cyberbullying should be criminalized. First up, for the affirmative side, we have Shan. Shan, you have 4 minutes to tell us why cyberbullying should be criminalized.
Sofia Santos, Eric Dumafiles, Gabriel Molina. They may have been forgotten, but they are among the increasing numbers of cyberbullying victims whose lives have been squandered at their very young age. Your Honors, ladies and men, good evening. In tonight's proposition, Your Honors, we affirm that cyberbullying should be criminalized to address the damnification within the cyber media and to the society. We propose that Cybercrime Prevention Act of 2012 be amended to the inclusion of cyberbullying in the prohibited acts thereto. Cyberbullying is hereby defined as an aggressive behavior or intentional harm causing harassment, intimidation, or humiliation which is carried out repeatedly and over time through the use of electronic medium in which online communication takes place. And it is characterized by an imbalance of power. It has the following elements. First, there is a repeated or habitual use of written, verbal, or electronic expression, or a physical act or gesture, or any combination thereof. Second, it is committed through a computer platform or anything connected to a network. Third, the act is directed towards another. And lastly, the act causes reasonable fear of physical or emotional harm and creates an hostile environment towards the victim. Your Honors, we stand firm that cyberbullying should be criminalized on the following grounds. First, the harm it causes to the society calls for the state's intervention. Second, the criminalization will address acts that are not encapsulated in the existing penal laws. On to my first argument. Cyberbullying inflicts an inconceivable amount of physical or emotional harm towards the victim. The torment leaves an emotional chilling effect that is engraved throughout his lifetime. But in most extreme cases, it may even lead to death of such victim, and it cannot be compensated by mere civil damages. The foremost consideration in the field of criminal law in the process of criminalization is the harm principle, pioneered by Sir John Mill, which provides that the only purpose for which a power can rightfully be exercised over any member of a civilized society against his will is to prevent harm, be it physical, emotional, and even psychological inflicted to others. This mischief brings about the compelling state interest to deter such act and to avoid the evil sought to be prevented. Moving forward, Mr. Honor.
Would you agree with me that there are already existing laws which will address the problem of cyberbullying? Like, for example, Republic Act number 10175, the Cybercrime Act. Like, for example, Republic Act number 9995, the Audio and Video Journalism Act of 2009.
Your Honor, in this case, cyberbullying has its own distinct features. It is habitually committed and it results to a hostile environment to the victim. May I proceed, Your Honor? So going forward to my second argument, cyberbullying is a new species that was not anticipated during the birth of the revised penal code in 1932. And it is yet to be addressed by any existing statutory law. Acts like habitual posting of an old photo for purposes of humiliation, internet trolling, posting of derogatory memes. Clearly, these acts are cyberbullying that cannot be penalized in view of the basic principle of nullum crimen nulla pene sine lege. This is neither within the coverage of the catch-all provision of unjust vexation, which was originated in the Spanish Código Penal in 1896. In cybercrime offenses, because cyberbullying is an aggression that is...
Angelica, you have 2 minutes to cross-examine Shan.
Good day, Mr. Speaker.
Good day, Counsel.
Are you aware of crimes against honor under the RPC?
Of course, Counsel.
So you know that it seeks to give protection to a person's name's honor and reputation.
Yes, Counsel.
Is a person's name, honor, and reputation attached to a person's dignity, one's dignity?
Of course.
Yes. So as to your stated definition of cyberbullying that causes harassment, humiliation, would you agree that such acts aim to embarrass and humiliate the victim?
Yes.
So having said so, these acts are the very acts crimes against honor seeks to address, right?
Counsel, there is a distinct feature.
So victims of such acts are already afforded remedy under the revised penal code.
What's that again, Counsel?
So victims of such acts are already afforded remedy under the revised penal
No,
code.
Counsel, there is a lack of protection to
So
such
criminalizing cyberbullying, as defined by the affirmative speaker, is not necessary since its aim is to punish the offenders
Counsel,
already punishable under the RPC.
Counsel, I've just discussed that there is a lack
So
of...
you said that the RPC is not somehow not updated, right? Since it did not see the future advancement of
yes, Counsel.
communication, right? However, is the RPC a general law?
Yes, Counsel.
So it
RPC.
finds general application, right?
Technically.
Are you aware of Section 6 that recognizes that the crimes under the RPC through and by the use of ICTs shall be punishable under
Counsel
said act?
remembers bullying
So the
is
Congress
not,
recognized the advancement of our
bullying
of
is
the
not
nation.
yet penalized. That's why cyberbullying is not
The
penalized
actions,
under the
Section 6 of the said cybercrime prevention law
Counsel, that's not
recognizes the
cyberbullying.
application of the revised penal code.
Counsel,
actions that
it
constitute,
fails
as you
to
have
address.
defined earlier,
Counsel, it fails to
Counsel,
address the
that the
habitual
acts of harassment, humiliation, and such acts are punishable under the RPC, right?
Counsel, under the
So-
provision
So
of
with
LKS Counsel
with the recognition of sections of the Congress
the
of
result
Section
is what
6,
we are punishing.
the RPC is still applied.
Angelica, you have 4 minutes to advance your argument on why there is no need to criminalize cyberbullying.
To criminalize cyberbullying is to infringe freedom of speech, a fundamental right that if so breached leads to greater evils. Your Honors, ladies and gentlemen, may I call on your attention to discern the affirmative's contention in the strictest sense. Pursuant to the case of Angladlad versus Comelec, it is of necessity that our worthy opponents must undergo the strict scrutiny test in demonstrating that criminalizing cyberbullying is of compelling state interest. In case of doubt, arguments should then be construed against the criminalization. Yes, Your Honor.
Would you agree with me that while it may be true that we have the freedom of speech, the same is subject to certain limitations?
Yes, Your Honor. We are not arguing that it is absolute, but we are arguing is that for infringement of such rights, strict scrutiny must be applied, and that there must be the present danger test should apply. To continue, to my rebuttals, victims' mental and emotional health are negatively affected, as said by the affirmative speaker. However, we say that there is no clear nexus between the cyberbullying and suicide, for there are multiple factors why a person chooses to take his own life. There are family problems, financial problems, and such. To my constructive, the negative beliefs that cyberbullying should not be criminalized, for it is not necessary, it is not beneficial, and it is far from being practicable. Criminalizing cyberbullying is not necessary for 2 points. First, acts which constitute cyberbullying as defined by our worthy opponents are already punishable under the revised penal code. And second, RA 1017-5, also known as Cybercrime Prevention Act, already increased the penalty for crimes committed through electronic means as provided for in Section 6. As to my first point, actions constituting cyberbullying as defined by the first affirmative speaker are already punishable under the revised penal code and special laws. Such acts result to cruelty, stripping of one's dignity, sow fear of physical or emotional harm, or incite violence in the environment, as said by the first affirmative speaker. These effects and results are the very evils sought to be addressed by the Crimes Against Honor under the RPC and other penal provisions. These actions fall under the crime of defamation, grave and light threats, as the case may be. And if, under the given circumstances, the aforementioned acts which constitute bullying lack any of the elements required under the law, the offender can still be prosecuted under Article 287 at the very least. Yes, Your Honor.
Counsel, wouldn't you agree with me that when we talk about cyberbullying, you talk of a different platform? Whereas conventionally, you can do those things, but right now, if you get bullied, it's going to be accessible to your parents, to other people as well. Don't you think the state has to come up with a measure to address this kind of magnified problem?
Yes, Your Honor. We see that the state has already addressed such concerns since under Section 6 of the Cybercrime Prevention Act, with the use or through the use of ICTs, all those acts punishable under the RPC shall be meted with a one higher degree of penalty. To continue, for unjust vexation to exist, as discussed in the case of Maderazo et al. Versus People, it is enough that the offender's act cause annoyance, irritation, vexation, distress, disturbance to the mind of the person to whom it is directed. On to my second point. Criminalizing cyberbullying is not necessary because RA 1017-5 of the Cybercrime Prevention Act already increased the penalty. If the aim of criminalization is to make people exercise discretion in their online actions through imposing a harsher penalty, the Cybercrime Prevention Act is already a sufficient framework. If the new law is enacted punishing the same acts already punishable under the RPC, this would run counter to the function of the Cybercrime Prevention Act and would only result to superfluity. Although we condemn any form of bullying, we see the negative...
Chan, you have 2 minutes for the cross-examination.
Good evening, Counsel.
Good day.
Counsel, are you aware of the ruling of Saldivar versus Sandigan?
Enlighten me.
Counsel, it provides for a balanced interest test for public orders or for crimes against public
Yes,
order.
and we see no
Counsel,
interest.
this bullying is against public order, correct?
Yes, Your Honor.
Therefore, cyberbullying should not be tested by strict scrutiny test, but within the balancing of interest.
We are talking about
Yes or
here,
no, Counsel?
it is affected.
Yes or
the
no,
freedom of
Counsel?
speech
Yes
is
or no?
affected. So
I'll take that as a
therefore,
yes,
the
Counsel.
strict scrutiny test must be
Counsel,
applied.
do you have any sibling?
Yes, I do have.
So, of course, you love your sibling, right?
Yes.
So, following that, would you do anything to protect him?
Yes.
So, what if someone posted any humiliating post continuously and
Although I love my sibling,
would
Counsel,
you
but
be alright with it? Is that alright for you?
Such is an
Would
isolated
that be
case.
alright for you, Counsel?
Such
Yes
would
or
be
no?
an isolated
So
case.
that would be
And
alright
so
for you.
balancing interest would not.
Counsel, would that be alright for you?
No.
The humiliation. Of course, if she committed suicide because of that humiliation,
Counsel,
would you
I
make,
have the
would that make it
option
worse?
to
Counsel, yes
file
or
a
no?
claim
Counsel,
against
yes or no?
unjust vexation in the
Counsel,
RPC.
yes or no?
Okay.
He committed suicide. Would that be alright for you?
No.
Of course, it won't. Then, if he committed suicide, would you charge me for unjust vexation? And would it be alright for you? And I will.
Like I said,
to be
Counsel,
punished
such is an
for 30
isolated
days.
case. Such an isolated case. And
Counsel,
the freedom of,
yes or no,
of
Counsel?
speech by reason of
Counsel,
isolated
yes or
case
no?
should not be warranted.
Counsel, yes or no? Would that be alright for you if that person will be punished for 30 days?
I would say that
For the
the
sake of
suicide
your-
of my sibling would be due to other
Counsel,
multiple
I'll just
factors
take
and
that
not
as a
only the
yes. No
cyberbullying.
further questions, Your Honor.
Second affirmative speaker, Wilmark, you have 4 minutes to tell us why it would be beneficial to criminalize the digitally evolving medium of bullying.
We cannot just allow cyberbullying pass before our eyes and let the resounding cry for help of victims fall on deaf ears. Your honors, ladies and men, good evening. My previous speaker has clearly established the rationale why it is necessary to criminalize cyberbullying. And on my rebuttals, negative was unresponsive and banked really on cyber libel, as if it is the same with cyberbullying. And yet, my first speaker actually made mention about the elements that would qualify cyberbullying. On his speech, he said,
that there is a repeated and habitual use of written, verbal, and electronic expressions or a physical act or gesture or any combination thereof. There is commitment through computer, platform, or anything connected to a network. The act is directed towards another, and the act causes reasonable fear or physical or emotional harm and creates hostile environment towards the victim. My previous speaker also made mention the necessity why cyberbullying has to be criminalized. First, the harm is caused to the society that calls for the state's intervention. And second, it will also address acts that are not encapsulated in the existing penal laws. Allow me to argue, Your Honors, how criminalization in cyberbullying will promote responsible and accountable cyber ecosystem in two levels. First, it will deter the exponential increase of cyber footprints. Second, it will further open the floodgates to fight other forms of cyber crimes. Now, on to my constructives. First, the Digital Report 2019 surveyed over 230 countries and revealed that Filipinos spend an average of 10 hours and 2 minutes on a device, making the Philippines emerge as the country which has the longest average of time spent using the social media per day, which is about 41%. From the 76 million internet users in the Philippines, Your Honors, almost 99% are on Facebook. What takes seconds to post lives on eternally. Your Honors, what we share online leaves an eternal footprint. The same with long-term effects and repercussions of cyberbullying to the victims. Hence our proposal to criminalize cyberbullying. The 2019 University of Buffalo research found that those cyberbullied more likely to suffer from poor sleep and depression, more likely to think of... Yes, Your Honor.
Why is cyberbullying not yet covered by laws such as against cyber libel or against unjust vexation?
Yes, Your Honors, because in terms of the nature and its offenses, they are very different, and thus cyberbullying has peculiarities and different elements as opposed to the other two. At the same time, cyber unjust vexation appears, while unjust vexation punishes hurt of feelings, cyberbullying is more than just hurting feelings. The impact of the form of aggression and the harm it can cause would leave eternal cyber footprints. So, moving on my argument. Second, we have started battling cybercrimes, Your Honors, just like cyber libel. While the technology continues to advance, new species of cybercrimes continue to evolve, not covered in the RPC and other statutory penal laws. Criminalizing cyberbullying could be a big step to open the floodgates to fight all other new cybercrime species. Your Honors, without the immediate action to address the inadequacy of laws, we shall continue to suffer from the detriments of technology, and achieving cyber wellness will just become a dream. In an Australian research, most adults responded that existing laws were ambiguous and needed to align with current behaviors, practices, and technologies. Thus, amending current laws to discourage cyberbullying was believed by 77% of young people and 66% of adults to be effective solution. The affirmative stance on the proposition. Thank you, and I am ready for the cross.
Clarice, you have 2 minutes to cross-examine Wilmark.
Good day, Mr. Speaker.
Good day.
Would you agree with me that the state has the duty to protect its citizens?
Definitely, Counsel.
Its protection is beneficial to us, right?
Definitely, Counsel.
Are revised penal code and special laws part of measures to protect its citizens, Mr.
Yes,
Speaker?
of course.
It needs, under RPC and special laws, it needs single act for the victim to have its recourse, right?
Enlighten me.
It is, Mr. Speaker. In cyberbullying, Mr. Speaker, is repetition of an act necessary?
It's habitual in the parameters set by the first speaker of the affirmative.
Do you agree that repetition of overt act causes more anguish than a singular act?
Actually, we're talking of the act or the
Answer
habit
me with a
here.
yes or no, Mr.
Yes.
Speaker. Applying for relief under cyberbullying that he presupposes that exists, the victim must be subjected to more anguish, right?
Yeah, party, yes.
Yes. From that, Your Honors, Mr. Speaker, exposing the victim to
What's
more
your point?
anguish
What's
is
your
the
point?
state's
Your question.
failure to protect its citizens as parents patriae due to existence of our existing laws. Next question, Mr. Speaker. The state has the you want it to be criminalized, right? Cyberbullying.
Yes.
Is new special division needed for its implementation?
Yes, definitely.
Hiring skilled information technologists are necessary, right?
Yes.
And they need salaries for that.
Yes, definitely.
That will be answered or paid for by the
Are you also aware that there are 39
Mr.
million
Speaker,
budget
the
allotted
state's
by the
budget
Cybercrime
would
Act?
be affected by creating a new division wherein in Cybercrime Act they are already covers such acts punishable under RPC
No, Counsel, it's
and
not yet
special laws
it's not
under
yet
Section
covered.
6 that aggravates the crime through
Clarice, you have 4 minutes to tell us why it would not be in the country's best interest to criminalize digital aggression or cyberbullying.
points of rebuttal before I proceed to my constructive. The affirmative posits that there are numerous reports of the increase of cyberbullying in our country. However, those reports does not equate to instances of cyberbullying in this state. Also, the affirmative posits that citizens are always online on Facebook. However, such being online on Facebook would expose us to harm. However, that's the reason why the state needs to provide proactive measures to educate technology users and to educate them on how they should use it properly without harming oneself. And to my constructive, criminalizing an act is not always the solution when our country faces challenges. Legislators must not limit their option to criminalization when available measures and relief to victims are present. Criminalizing cyberbullying is not beneficial because first, criminalizing it does not equate to effective deterrence but proactive measures. And second, recourse available under the civil aspect is more efficient and effective. For my first point, criminalizing cyberbullying is not an assurance of deterrence. Oxford study has shown that the criminal law does not deter due to different factors, including the behavior of an offender. That despite knowing the existence of penal law, yes, Your Honor.
Counsel, isn't it a legitimate state interest to police and regulate people's behavior in the internet? Because is it not a possibility that the reason why people are so quick to bully in social media is it's because they know that the government does not regulate them as much? What are your thoughts?
For that, Your Honor, since the if Cyberbullying Act will be passed, it will infringe the freedom of expression of a citizen that must, in order for it to be constitutional, it must pass the strict scrutiny test and it must show that there is clear and present danger in the country. Proceeding, Your Honor. Under risky shift phenomenon, perpetrator chooses to neglect the legal consequences and underestimates the risk of being caught. In cases of cyberbullying, criminalizing it would not discourage cyberbullies due to complexity of technologies. Cyberbullies through dummy accounts and hiding their location can escape liabilities. It is not an effective deterrence, for perpetrators are less likely to be caught. Rather, implementation of proactive measures that would not only combat cyberbullying but would address the underlying cause of its existence is more encouraged as deterrence per United Nations Crime Prevention Guidelines. Further, the fact that proactive measures deter cyberbullying is evidenced by lack of penal sanctions in Anti-Cyberbullying Act but presence of proactive measures. For my last point, Your Honors, human relations provisions, specifically Articles 19, 20, and 21, under the new Civil Code, govern the interrelationships of human beings in a society for the purpose of maintaining social order and acts contrary to this, like cyberbullying, creates civil liability. Montañez versus Mendoza ruled that in civil cases, preponderance of evidence is needed, as opposed to conviction in criminal proceedings requiring proof beyond reasonable doubt. Based from the quantum of evidence needed, civil liability of a cyberbully is easier to prove. Victims are required to present their pieces of evidence that outweighs the evidence of the accused without overcoming the presumption of innocence of the latter for the recovery of damages. Thus, it can be concluded that civil liability is an effective recourse for the victim. Cyberbullying is an act that must be frowned upon. However, it is not beneficial.
Well, Mark, you have 2 minutes to cross-examine Clarice.
Good day, Counsel.
Good day, Mr. Speaker.
Council, do you agree that in this world change is inevitable?
Yes, Mr. Speaker.
That's great. So what is new today will definitely be obsolete tomorrow, right?
Not necessarily, Mr. Speaker.
Not necessarily, yet you agreed and subscribed that change is inevitable.
It might
Alright,
change.
continuing my... Would you agree with me that the means of a living also changes or evolves through time?
Yes, Mr. Speaker.
Alright, that's good. So laws and statutes we have must also be adaptive with the inevitable changes of time.
Yes, that's why Section 6 of the Cybercrime Act.
Alright, Council, are you not aware? Are you not aware of the dynamic principle of laws?
Again?
That explains because your answer should have been yes. Council, do you believe that bullying is bad?
Yes, of course, but not all wrong acts must be
Definitely. I'll
criminalized,
take
Your
it as a
Honors.
yes. More so if it will harm others, right?
Yes, but not necessarily it
Precisely.
should be
Thank you.
criminalized.
All the
Mr.
more that
Speaker.
bullying is bad when it is done cyberspace, right? With a larger audience.
Yeah, that's
Council.
why there's
Thank
Cybercrime
you. I'll take
Act,
it as a
Mr.
yes.
Speaker.
So you'd also agree with me, Council, that acts that harm others, must be penalized.
There's civil liability, but
Council,
there's
no
not
wonder that your
necessarily
proposition
criminalization
is
answer for all
flawed
your-
because people are already being harmed and yet you're not doing anything. Therefore, Council,
Mr.
therefore, Your
Speaker, there
Honors,
are,
the Speaker
other
agrees
recourse.
with me that cyberbullying should be criminalized in response to the changing times and thus accurate punishment
Mr. Speaker,
shall be applied
questions,
thereto.
please.
No further questions, Your Honor.
Third affirmative speaker, Carissa, you have 4 minutes to tell us why it would be practicable to consider cyberbullying a crime.
Ladies and men, tonight's proposition challenges each bench to answer the issue on whether or not the existing laws are adequate and effective to deliver justice to cyberbullying victims. A perusal of the arguments made of the affirmative and the negative would tell us that the negative seems to undermine the effects, which makes cyberbullying even more harmful. Whereas we would like to point out in the affirmative side that the unjust vexation would be different in nature because of unjust annoyance. Cyber libel would be different because of the defamatory in nature, whereas cyberbullying is aggression and its nature is very distinct from the other crimes. RPC and special laws are, of course, being respected in this case. However, we would like to just establish something that would make them adequate for the new crimes that are existing to be addressed. And also, it assumes, the negative side seems to assume that just because we do not have enough IT experts, we can no longer do anything about this. However, Your Honors, we cannot use the reason of the difficulty in prosecution just because of the cybercrime division or the IT experts to limit the extent of protection we can provide to the public and the justice we can deliver. Hence, cyberbullying should be criminalized by amending the Cybercrime Prevention Act of 2012 on the following grounds. First, that cyberbullying also causes harm against the public, not just the victim. And second, the amplified bullying effect must be put to stop. Now, unless provision is crafted to consider cyberbullying's unique circumstances and nature as discussed by our necessity speaker, the lurking harm in the cyber ecosystem will continue to create a chilling effect. As revealed in the study called Computer in Human Behavior, people confuse cyberbullying with humor. Sadly, this worldwide dilemma where digital cruelty... Yes, Your Honor.
Mr. Speaker, how exactly are you going to enforce a law that requires you to prove beyond reasonable doubt that his post caused her to feel afraid?
Your Honors, what we are trying to establish here is that the element of simply attacking someone when it comes to defamatory would go beyond the harm that it causes because of the repeated, the habitual nature, the hostile environment it produces. May I continue, Your Honor? Thank you. Now, just imagine the extent cyberbullying creates. The perpetrator easily finds his target online and then inflicts harm against the victim. And with one click, the rest already knows and leaves a cyber footprint. According to the culture of cyberbullying in the Philippines, 21% of the 79% Filipino internet users would constitute group bullying or cyber mob. There is no even need for people to actually know each other, but yes, Your Honor.
I just would like to know, since they were banking on freedom of speech, what
Yes,
is
po.
the affirmative's response to that particular contention?
In the case of Saldivar versus Sandigan Bayan, one of the tests to limit free speech is the balancing of interest test, where such funny comments of the bully shall be weighed alongside the effects to the aggrieved party, which Justice Learned Hand also said that courts must ask whether the gravity of the evil discounted by its improbability justified such invasion of free speech as is necessary to avoid the danger. Hence, the cyber community is already larger than the community we build face to face, and the free speech is not being infringed here because in free speech, violates the right of another. Hence, once again, we bring you, yes, Your Honors.
How sure are you that, as you said earlier, criminalizing cyberbullying is a must? How sure are you that it would really deter the commission of crimes? Because if you can recall, before we had death penalty, but yet it did not deter the Filipinos from committing crimes punishable by death penalty.
Your Honor, as we have established earlier, the changes that we are experiencing in the technology cannot be already measured.
Thank you. Christina, you have 2 minutes to cross-examine Carissa.
Good day, Madam Speaker.
Good day.
May I assure Madam Speaker that you are a social media user?
Yes.
Are you aware of the rampant commenting, sharing, and posting on Facebook, Twitter, and other
Yes,
platforms?
that's part of the
Can you
social
consider
media.
that as modes of expression?
Yes, of course.
Since it is an exercise of expression, then any infringement of it must undergo scrutiny, right, Madam Speaker?
Yes.
Do you agree with me, Madam Speaker, that cyberbullying is concerned on the content of the statement or the comment?
More than just the content, the harm it creates.
Then the more reason that there is strict scrutiny as it is content-based, Madam Speaker, right?
Not just the content.
But Madam Speaker, it is content-based, right? Because you're saying that it should result to fear and emotional stress,
We
right?
have provided different elements,
Then,
counsel.
Madam Speaker, it is under the Chavez versus Gonzalez case that it should undergo strict scrutiny if there is content-based restriction.
It's beyond
On
just
to
the
my next
content,
point,
counsel.
Madam Speaker. Freedom of expression is a right that presupposes the free flowing of ideas, comment, even if it counters another's belief, right?
Yes, but this is
Do you
not just
consider
about free
yourself as a
speech.
person of high intelligence, Madam Speaker?
Yes.
Will you be able to know all of your Facebook friends' thoughts on a meme or status you shared? No? No, then Madam Speaker, you may be a cyberbully yourself because I or any of your friends may be offended of the said post, right?
No, that's not the point here.
But
We have
Madam Speaker,
established the
cyberbullying
elements that
is
if it is
concerned with how you are
habitual,
going
it
to
has to be
invite-
aggressive in
Madam
nature.
Speaker,
That's why we
Madam
have
Speaker,
established the elements.
If I am affected, I can claim that I am
Counsel,
bullied,
this
Madam
is not
Speaker.
just about
Madam
hurting
Speaker,
feelings because it's beyond
Madam
hurting
Speaker, it
feelings.
is on your element. The fifth element of provided by the necessary
A hostile environment which is
a result
created.
of fear and emotional
we did not
distress,
mention
Madam
about
Speaker.
the fear.
No, there is
We
fear and
mentioned about the
emotional distress
hostile
from the-
environment.
Madam
The
Speaker,
hostile
Madam
environment.
Speaker, there will be undue restriction of one's freedom of expression if there is an additional requirement that is exercised, right?
Of course.
Then to criminalize cyberbullying is to add an additional requirement to the freedom of expression. I rest my case, sir.
Christina, you have 4 minutes to tell us why it would not be practicable to criminalize cyberbullying.
Good day, Your Honors, my worthy opponents. Before I proceed with my constructive, allow me to rebut the arguments of the affirmative side. It is their argument that welfare of the Filipino should be a priority. We agree that welfare of the Filipino is a primordial concern. However, we cannot agree with the affirmative that curtailment of the freedom of expression is the answer. There should be consideration to balancing of interest. In this case, the curtailment of freedom of speech, the reason of on to my next point, it is not practicable to criminalize cyberbullying as it would be tantamount to undue restriction of the constitutional freedom of expression. In the case of Chavez versus Gonzalez, restraints on freedom of speech and expression are evaluated by the clear and present danger test. It is not enough to determine whether the challenged act constitutes some form of restraint. There has to be distinction if it is content neutral or content based. And we rally that criminalization of cyberbullying is basically a content based restriction as it is focused on the subject matter of the utterance or speech. A governmental action, yes, Your Honor.
Are you saying, Ms. Speaker, that if you can show criminal intent on the part of the one who posted, then it's okay to criminalize?
No, Madam Speaker. We are arguing that this is a content-based restriction. The offender cannot always say that he knows what the others would feel about his communication. May I proceed, Your Honor? In the case of Cabansag versus Fernandez, the clear and present danger test means that the evil consequence of the comment or utterance must be extremely serious and the degree of imminence extremely high. Let us be reminded, ladies and gentlemen, that not every violation of law will justify straitjacketing the exercise of freedom of speech. There are laws of great significance offense, but their violation by itself and without more cannot support suppression of free speech and free press. The totality of the injurious effects of the violation, the private and public interest, must be calibrated in light of the preferred status accorded by the Constitution. And again, the need to prevent their violation cannot per se trump the exercise of free speech and free press, a preferred right whose breach can lead to greater evil. In summary, the negative side argues that cyberbullying should not be criminalized, as it is not necessary due to the existence of the same acts under the RPC and harmonized with special laws. It is not beneficial, as imposing criminal penalty does not deter the conduct it sought to prevent, and the recourse to civil aspect is more effective. It is not practicable, as it is an undue restriction to the freedom of expression. I rest my case, Your Honor, and now ready for my interpellation.
Carissa, you have 2 minutes to cross-examine Christina.
Good day, Counsel.
Good day, Your Honor.
Counsel, with your extensive research, I believe you have already encountered a story about bullying. Is that
Yes,
correct?
Madam Speaker.
And that you have most likely learned that there are a lot of ways to commit such act.
Yes,
right?
Madam Speaker.
Would you agree with me that inflicting pain against someone over and over is bad?
Of course, Madam Speaker.
And when done online and publicly, it creates a larger audience, right?
Yes, Madam Speaker.
That if, say for instance, a photo is used to inflict pain against someone, inflict pain directly, there can be unlimited copies even if you take down the original one, right?
Yes, Madam Speaker.
And that the shares, comments, and reactions publicly done can be difficult to control, right, Counsel?
Yes, Madam Speaker.
Now,
that's
Counsel,
true.
given the circumstances which consummate the elements of bullying, would you agree with me that it is not just a mere act of annoying someone?
No, Madam Speaker, it does
Of
not
course,
follow because I can claim I am
of
offended
course,
by a
that
specific
is going to
photo
be
that you
answered.
just
Let me
shared.
just continue.
Yes, Madam
And that bullying online is it's not only about tainting one's honor.
Not necessarily, Madam Speaker.
Of course. Hence, Counsel, with your answers, do you still think that cyberbullying is not distinct in its own and that it doesn't
It should not be
inflict harm
separate and distinct from the
towards
crimes that are committed
Do
under
you honestly
RPC.
think that cyberbullying is just simply about freedom of expression? It's just simply
No,
about
Madam Speaker, but that
it's
should
just
be
simply about
balancing
that?
of interest in this case. We cannot suppress the freedom of expression just because there are isolated cases.
What about the inflicting of harm, Madam Speaker?
Madam Speaker, there are other
What about the
recourse.
inflicting of harm? Do you think that
There
can
are other
be
recourse.
just
I
shied
think
away?
there
This
are
can
other
be
recourse.
brushed away?
There are
Yes
other
or no,
recourse, Madam
Counsel?
Speaker. No, there are other recourse, Madam Speaker.
Yes or no, Counsel?
There are other recourse. I will stick to my answer, Madam Speaker.
There are no other recourse,
There are other
Madam
recourse.
Speaker,
There are
because
other recourse,
once there is harm inflicted over another, and when the elements are established, this would constitute cyberbullying. No further questions, Your Honor.
Thank you, Madam Speaker.
And with that, we end the debate proper. We now invite both sides to cross the House as our judges tally the scores. We'll bring you the results next. Please stay tuned.